Very good evening, dear friends. In this particular session, I would like to deal with the acceptance of fixed deposits by companies. Actually, friends, the acceptance of fixed deposits from the public by way of giving an advertisement attracts the same provisions of prospectus related to public companies, and then the same compliances have to be made. And apart from that, the company's acceptance of deposits rules 2014 also must be perused in this regard. And then these particular rules, in fact, and provisions, section 73 of the Companies Act 2013 earlier reflects correspondence to section 58A of the 1956 Act and the rules thereon. Today, separate companies' acceptance of deposits rules 2014 have been framed thereon. Then, friends, section 73 says that there is prohibition on acceptance of deposits from public on and after the commencement of 2013 Act. No company shall invite, accept, or renew deposits under this Act from the public except in the manner provided in this chapter, and it has to be read with the Company's Acceptance of Deposit Rules 2014 also. Then, friends, provided that nothing in this subsection shall apply to a banking company or non-banking financial company as defined in the Reserve Bank of India Act, and such other company as the central government may, after consultation with RBS, specify in this behalf. The same old provisions will continue here also. Then a company may, subject to passing a resolution in general meeting and subject to such rules as may be prescribed in consultation with the Reserve Bank of India. Here, Reserve Bank of India would be consulted by the MCA. Can accept deposits from the members on such terms and conditions, including the provisions of security if any, or for repayment of such deposits with the interest as may be agreed upon between the company and its members, subject to fulfilling certain conditions. What are they? There are about six important conditions. 1. Issuance of a circular to members, including therein a statement showing the financial position of the company, the credit rating obtained, the total number of depositors, and the amount due towards deposit in respect of any previous deposits accepted by the company, that is earlier accepted, and such other particulars in such form as could be prescribed from time to time. Then filing a copy of circular along with the statement with the register of companies within 30 days of the date of issue of the circular. Depositing on or before the 30th day of April each year, such sum which shall not be less than 20% of the amount of the deposits maturing during the following financial year, and kept in a scheduled bank in a separate account to be called Deposit Repayment Reserve Account, so that it would act as a security for the repayment to the depositors. Then certifying that the company has not committed any default in the repayment of deposits accepted either before or after the commencement of this Act, or payment of interest on such deposits, and where a default has occurred, the company made good the default, and a period of 5 years had lapsed since the date of making good the default, and providing security if any for the due repayment of the amount of this particular deposits or the interest thereon, including the creation of such charges on the property or assets of the company. There is a lot of improvement now. Earlier, this was not the case. The rank is unsecured, in fact, liabilities, but today, unsecured creditors, they were earlier, but today there are a lot of, provisions have been made out as security for repayment of deposits as well as interest, and all the depositors, in fact, can move the National Company Law Tribunal also in the event of non-payment. And where the company does not secure the deposits or secures such deposits partially, then it shall be termed as unsecured and shall be so quoted in every circular, in the advertisement also. And then every such deposit accepted by a company under these particular provisions must be repaid with interest in accordance with the terms. And where it fails, now this is the most important, the depositor consent may apply to the National Company Law Tribunal for an order directing the company to make the payment. And also claiming any loss or damage incurred by him as a result of non-payment. and the deposit repayment reserve account so and so shall not be used by the company for any other purpose other than for repayment. Now section 74 deals with repayment of deposits etc. accepted before commencement of this act, and 1 year time has been stipulated for this particular repayment. Section 75 deals with damages for fraud, where a company fails to repay the deposits or part thereof for interest thereon referred to in this particular section 74 within the time specified or within further time as may be allowed, then it is proved the deposit has been accepted with an intent to defraud the depositors or for any fraudulent purpose. Every officer would be responsible for the acceptance of the deposit shall be without prejudice to the provisions contained in subsection 3 of section, and liability under section 447 be personally responsible without any limitation of liability for all losses or damages of the depositors. Then any suit proceeding or action taken by any person, group or persons or association who had incurred any loss as a result of failure to repay or interest thereon. So what it says is, any suit proceedings or other action may be taken by any person, group or persons or any association who got into any loss, and they can take appropriate steps. Then under section 76, the acceptance of deposits from public by certain companies, a special provision has been made. Notwithstanding anything contained in section 73, a public company having such net worth or turnover as may be prescribed may accept deposit from persons other than its members, subject to compliance with the requirements provided in subsection 2 or 73, subject to such rules as central government may stipulate. Then the punishment for contravention of section 73, 74, contravention is under 75. 73, 74 is existing. 70 before existing before 2013 Act. 73 is after 2013 Act. Then the punishment here is even for public for by other companies, section 76. Now the particular penalty is that in contravention, if this or any violation of the order of the tribunal, the company shall, in addition to payment of amount of deposit or part thereof or interest, be punishable with fine, which shall not be less than 1 crore or twice the amount of deposit, whichever is lower, but which may extend to 10 crore rupees. This is the most important provision. And every officer of the company who is in default shall be punishable with imprisonment which may extend to 7 years, and with fine which shall not be less than 25 lakh rupees, but which may extend to 2 crore rupees. If the amount is not paid, then he will undergo further imprisonment also. Further, if it is proved that the officer is in default has contravened provisions knowingly or willfully with the intention to deceive the company or depositors, he shall be liable for action under section 447 also. I have also told you about 447 earlier, that it's a general provision, and then under 447 Act, in fact, a separate punishment has been stipulated. 447 is punishment for a fraud, miscellaneous, and then where it is stated that the punishment is whoever is found guilty of fraud involving the amount of at least 10 lakh rupees or 1% of the turnover of the company. In fact, what is stated here is that if any person who, under 447 who is found to be guilty of fraud involving an amount of at least 10 lakh rupees or 1% of turnover of the company, whichever is lower, shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 10 years, and shall also be liable to fine which shall not be less than the amount involved in the fraud, but which may be extended 3 times the amount involved in the fraud. Provided where the fraud in question involves public interest, the term of imprisonment shall not be less than 3 years. Then it would be a cognizable offence. Provided further where the fraud involves the amount less than 10 lakh rupees or 1%, whichever is lower, it does not involve public interest, any person guilty of such fraud shall be punishable with imprisonment of a term which may extend to 5 years, or with fine which may extend 20 lakh rupees, or with both. So these are all the basic provisions pertaining to this particular acceptance of fixed deposits. And then in fact there are separate provisions in fact made out, wherein separate punishments also have been stipulated for acceptance of fixed deposits by the company. It is no matter, even a private company is liable, and then it has got to return the money it has collected thereon. So with this background, friends, we will conclude our discussion on this particular acceptance of fixed deposits, and then we will see other provisions later on. Thank you very much. Good night. Bye-bye.